Should lawyers prepare wills only or people do it themselves? Is that valid?
You can do your own will, but it has to be entirely in your own writing and it cannot have witnesses.
How long could a will take to be settled? And
My worst case was 10 years.
Wow.
The general rule is 1 year. It fluctuates, depends on the asset base that you're dealing with.
I'll give you a few scenarios. What happens in Ontario if someone dies without a will? Now that person has certain assets, but he was single, never married, no children.
So if you die without a will, the estate trustee of last resort is the office of the public guardian trustee.
Same situation in this case, a person dies without a will but has a spouse, no children.
Now you can apply to become the estate trustee without a will.
So the spouse can apply?
The spouse can apply.
Okay. Should adult children have a part in the will even if their names are not there?
The will is the testator, the person who dies, it's their intention. The goal is that document is purely their intention and there is no undue influence.
If someone uses AI to prepare a will and it's challenged later, whose responsibility could it fall on?
Conceptually, AI goes out there, picks up a whole bunch of data and tries to align it to you. That doesn't align with a will.
Hi, I'm Manish Kapoor tuning in from Canada, and I'm really glad you're here. This is where we sit down with some amazing minds, leaders, creators, and change makers to talk about the things that matter. Every episode is a chance to learn something new, get inspired, or just hear a fresh take. So let's get into it.
On today's episode of the Kapoor podcast, we are joined by Raj Sharda, a prominent lawyer in Brampton, to discuss an important topic that affects every family: wills. Many people put off creating a will thinking it's something they'll deal with later, but the reality is that life is unpredictable. Mr. Sharda will share why having a will is crucial for protecting your loved ones, avoiding costly legal disputes, and ensuring your wishes are respected. We'll dive into the common mistakes people make, the legal challenges that can arise without a will, and practical tips for getting started. Whether you think you are too young, too busy, or just don't know where to start, this conversation will give you the clarity you need to take action. So let's get into it. All right, Mr. Sharda, thanks for doing this with me. I'm pretty sure this will be a very informative session. We'll start off asking you some very simple questions, fun questions, and then we'll get down to the real stuff, okay? So which is your favorite city in Canada?
I'd say home is Oakville.
Oakville? Yeah. That's your favorite city?
Well, that's because I've grown up in Oakville.
Yeah. Oh, that's great. Yeah. And what do you prefer, summer or winters in Canada?
I'd say summers.
Summers?
Yeah.
Oh, I think everyone does. So, great. And then what can you do, or rather cannot do without, a phone or a laptop?
Laptop.
Laptop?
Yeah.
You need that.
Well, I'd rather not have the phone, but
yeah.
You need it. So.
I know. True. Okay, so now we'll get down to some real questions about wills, all right? So what is a will and should everyone have a will?
So I'll answer the second question first. The answer is yes, you should have a will. What is a will is your proactive wish to say, when I pass away, what should happen to the assets that I own? It's you sitting down and making those determinations. Who is going to step into your feet and act as you to sign off on documents to allow things to move? And then to whom are you giving the assets that you want to leave, right? So that's really what a will document does. But in my mind, the first instance is that the person needs to make those decisions. If the children are underage, who's going to be their guardian? Who's going to be their trustee? What age do you want your children to have assets? Those are the type of things that wills will do. So it's once you've started that conversation with yourself and you've made a determination that, yes, I want to do this proactively, then you need to get a legal advisor, a lawyer, and say, okay, this is what I want to do. and then they can start moving on drafting a will to achieve your goals. So that technically is what a will document is.
And what is the best age to prepare a will?
Probably once you have some assets, A, or B, if you've gotten married, if you have children, like it follows your life course. So once you're at a position where you have responsibilities, obligations, and that if you're no longer here, who will decide for you? I think that's when you need to start saying, okay, I need to plan for this.
Okay.
Right.
So you would say after marriage, for sure, people should start considering this.
For sure, but these days younger kids have significant assets.
Mm-hmm.
And although youth believe they'll live forever,
Yeah.
if you have a good significant asset, you should think about if something happens to me, what happens to those assets. So,
Okay.
so any significant life change
Mm-hmm.
would probably trigger the requirement of a will.
Okay. And should lawyers prepare wills only, or other people like accountants or people do it themselves? Is that valid?
So I'm going to break that question down. Who should prepare a will? If you're going to do it by a professional, then lawyers are the professionals you should be going to.
Okay.
I mean, I don't fix my own car.
Mm-hmm.
I go to a mechanic or an IT expert because
Sure.
they're all computerized now.
Yeah.
So I wouldn't recommend that you do it yourself. Now, having said that, you can do your own will, but it has to be entirely in your own writing, and it cannot have witnesses. That is called a holographic will.
Okay.
Now, sometimes because people are very money conscious, they think that's the right way to go.
So you shouldn't just type it off on a piece of paper.
If
or
you
something.
type it, it's not going to be a valid holograph because by
Okay.
definition, holograph means in your own writing.
I see.
So it can't
And
be
no
typed.
witnesses.
No witnesses.
Okay.
Yeah. Now, the problem with that scenario, the holographic will scenario, is if you miswrite, you've not conversed with anybody,
Mm-hmm.
and there's nobody there to say, oh, this is what you meant.
Mm.
Right? I
Yeah.
mean, a prime example, recently I have had a litigation case where the lady didn't want to spend money. She used to be a secretary for a lawyer. She took the old bank statement, and on the back of the bank statement, she didn't even get new paper. She was so frugal. She wrote her own will.
Yeah.
But the wording she used caused the will to be challenged. We were able to probate it,
Yeah.
but at distribution, other siblings then challenged it, saying, she almost made it conditional by saying, in the event I die unexpectedly,
Yeah.
which now becomes like a conditional will.
Okay.
And then who determines, was that an unexpected death or was it a expected death? Because we all die.
Mm-hmm.
So that caused problems, and the way she worded the grant, it was not clear.
Yeah.
That caused trouble. So the problem with doing your own holographic will, unless it's simply like, I leave Mr. Kapoor everything I own, period. And if I know Mr. Manish Kapoor, make sure, I've identified the Kapoor that I want to give it to.
Right.
Then that's not challengeable. But anything which can be interpreted
Mm-hmm.
is problematic because there's nobody who can say, yeah, I met with the person. This is what they said, and this is what they meant. And that's why using a lawyer for your will is also important, because you have a sounding board to say the lawyer can come in and say if your will is challenged, the lawyer can bring in his notes or her notes, come into court and say, I met with the person, this is what they said, these are my notes, and then the challenge can be addressed because there's somebody there who recorded your wishes other than what's in your head.
Okay.
So that's why holographics can work, but they are dangerous. And
I
they may well lead to litigation, especially if you have the next level is contentious.
Yes.
So that's why you have to be careful on holographics.
So highly recommend that a lawyer prepares a will, just
Yeah,
so that it's valid and.
I think so. I think people get scared of legal fees and they think, oh my God, I'm going to have to pay for. But for less than the price of a TV,
Mm-hmm.
you and your spouse can get a basic will done.
Yeah.
And then when you have that, you have peace of mind that if you die tomorrow, somebody knows what your wishes are.
Yeah.
And your beneficiaries have peace of mind that my parents have planned for my future.
Yeah.
And in the event, unexpectedly or otherwise, they pass away, which you're going to pass away anyway, they've already planned for it. So I think there's value in doing it with the professionals.
So you've brought this up less than a value of TV. What would normally be a charge in today's day for a couple to prepare a will?
A basic package is probably around $1,000.
Okay, so for two wills.
For two wills, the necessary documents, the affidavits of execution.
Yeah.
That may also include your power of attorneys. Many lawyers will do that as well,
Okay.
all as a package.
Yeah.
But what you have
So
to
1,000 to 2,000, you can get everything done.
that would be fair on a not a very sophisticated asset base.
Okay, a simple will.
Yeah, simple.
Okay, perfect.
Because today's environment, assets are very complex.
Sure.
And they trigger many different consequences. So you have to do a bit more planning on that type of stuff.
So once the will is prepared, who holds the will? So if I prepare a will, now who do I give that will to?
So in the past, I've been out almost 30 years. So in the past, we used to, lawyers tended to hold the wills
Okay.
in the expectation that the estate administration would come to them. When the children come looking for the will, they'll see the lawyer's card, they'll come and get the will from you. And hopefully that work would flow. I know with a lot of retirements, the Law Society's obligations are that you have to find, if you retire or you close your practice, you have to actually locate the person who did the will and get the will back to them. Now, if you've had a 25, 35-year practice and you have wills that are 20 plus years old, you may not be able to locate those people.
Right.
And so I think more than now, you are giving the originals to the clients
Okay.
under the caution that if they lose it, they have no will. What they can do is use a copy, but you'd have to go to court to get that authenticated because your original is no longer available.
So the client holds the original will where? In
That's
their
my practice
locker
now.
or in their house?
So it used to, one of the places is actually in your freezer.
Okay.
Because if you have a fire,
Yeah.
the plastic seal and your freezer is safe.
Right.
Okay. But in a safe place, but there's two things about that. Because you've named an estate trustee to step into your shoes, there's no sense in making a will, putting it away somewhere, and not telling anybody about it. So I think the bigger question really is for families is if the parents are now deciding to make a will, when they decide to make a will, they need to have an open discussion with their children
Okay.
and the family and say, okay, we've made a will. They need to assess, even if you may say, oh, this is my oldest child, obviously they'll take on the responsibility. Maybe that child doesn't want that responsibility. And you will know the dynamics of your children. And you may be that, you know what, I think my middle child is a bit more responsible than my older child. I think I'll make the middle child. And so often you'll see parents with this dilemma, like, do I give it to all three kids? But if they don't cooperate, you're causing trouble. So I think the parents have to have that discussion with themselves, frankly, and then have it with their kids and say, all right, this is what we're done. And even in a situation where they may say, we're not giving you anything. We're giving you the responsibility to distribute our assets, and it may all go to charity or it may go somewhere else. Why? Because we already given to you and you guys are established. You don't need it, but our wishes are, because that's what you have to remember. A will is not the children's wishes. It's not what your spouse is. It's your wish.
Yeah.
What do you want to happen to your assets? Now, you have obligations. If you have a spouse and you have children, minor children, you may have obligations that your estate has to abide by for dependents, etc. But in general, it's your wishes.
Perfect.
Yeah.
So say I have a will, I've put it away in a locker, and then...
That's another thing about the locker.
Yeah.
If you put it in your bank locker,
Yeah.
make sure that the estate trustee is a co-signee to the bank locker.
Okay.
Because the bank won't give them a key.
Good point.
So they need to have a key. So wherever you put it, the estate trustee needs to have access to the original document. So if
Okay.
you have it in a safe in your house, make sure you tell them the code. So these simple things you have to be careful about.
So let's go there. How do I appoint a estate trustee or an executor, and who would be the right person?
So how is simple? You'll end up citing it in the will,
Yeah.
right? Who is the more difficult? And as I gave you that previous example, sometimes you do your children.
Yeah.
Sometimes if you have a significant asset base, what you will do is you might pick a trust company or a bank to do the estate work for you
Okay.
because you have significant assets.
Yeah.
If you pick children, again, you should do that assessment of who are you comfortable with, right? And cultural influences come into play sometimes. I've had in the past people say, well, I'll give to my sons, I won't give to my daughters because culturally that's the thing, the way they think they should do it.
I've heard that, yeah.
Yeah. And I always remind them that the Canadian system is a more equal system. Everybody, if you're going to give everybody, and if you're not going to give, then give a valid reason.
Yeah.
They may not like the reason, but as long as you have given a thought-out reason.
So on your will.
Yeah, in the will
okay.
you will say, I am not providing anything to so-and-so because, for instance, over their lifespan, I've provided them all these assets. Okay? Or they have been so successful, that child doesn't need anything, but this child does.
Okay.
So as long as you explain, because the test is capacity. So if there's no logical reason for why you're doing something, somebody can challenge your capacity and say, well, I don't think this person was capable. Now, you can either do it because there's no logic to what happened, or there's actual medical evidence that when the will was done, because you do get this where mom and dad go to live with one child, and it becomes a will, and then mom and dad go to live with another child, and all of a sudden there's another will, and they're diametrically opposed. And the question is this mom and dad's intention, or is as they get older, are they getting vulnerable to input from their children and doing what the children are wanting as opposed to them? And that's where challenges will come.
Okay.
Right, and it's not. You'll get it even in fully wills where this is what the person's wishing. You can't control what your children will do, right?
Okay.
But there's that you have to be careful.
And if someone has a substantial asset base, as you mentioned, children might not be the right choice. So,
as an executor.
So how does someone identify that this trust company or this bank is a good alternate?
Interview them.
Okay.
And get a feel for what they do. They obviously will charge fees, and they usually have a threshold that a certain asset base has to be above that.
Yeah.
And usually it flows from you have financial advisors with an institution. They will connect you to their estate department.
Yeah.
And so generally that flows. And then with power of attorneys, because that's more of a personal thing, especially the personal care one, you would probably have more input of the family.
Yes.
Right? Like, I mean, I come from a South Asian background. There seems to be a lot of doctors in the South Asian children.
Yeah.
So, they usually you say, well, look, that guy's a doctor, give him the medical stuff because he should know what he's doing, right?
Absolutely.
So it's you as a testator, the person writing the will, needs to be comfortable that the responsibility I give to somebody, are they willing to accept it and perform it to the satisfaction that I would want? B, once they've accepted it, do they have the capacity to deal with the breadth of assets I have to make sure they get distributed in the most economical manner? And on that note, like nowadays, you're looking at a team. You're looking at, it's not just the lawyer. The lawyer will do the drafting, but the input comes from your accountant. The input may come from your financial advisor, because different assets may have to be dealt with differently to maximize value. And then you also have the tax consequences. I tell clients, I'm not an accountant. So you tell me how you want it done. I will draft the documents accordingly, but I'm not going to give you tax advice.
Yeah.
And then when you're dealing with investment institutions, they have their own rules and regulations. So you might say, I want to do this, and you're dead, and now you go to the institution. The institution, well, no, that's not how we do it. You should have done X, Y, and Z. So that's why it's an input of information from varieties of areas.
Yeah.
Because of the nature of our investments.
Right.
And probate considerations are one aspect, but not all the aspects. Right. So I'm looking at, so even on a simple will, like for probate purposes, the death benefit from CPP and any tax returns will be payable to the estate.
Yeah.
And no matter, that's only $2,500 and you don't know how much your tax return is going to be. It could be only thousands of dollars. But the bank is going to say, no, open up an estate account, put the money into the estate account, then you can distribute it.
This episode is sponsored by Kapoor Law Firm, your trusted real estate law firm serving all of Ontario. Whether you're buying, selling, or refinancing a home or business, their expert team can guide you through every step. And here's a bonus for our listeners. Subscribers to this show can receive a one-time coupon for their upcoming closing. Visit thekapoorpodcast.com to claim yours. Again, this might not be a good question, but how long could a will take to be settled? A simple one, and
my worst case was 10 years.
Wow.
But there was issues.
A lot of complications, yeah. And for a simple will?
The general rule is 1 year.
Okay.
But you have to understand, our asset bases are complex now.
Yes.
So in lawyer drafted will, you will have rules and regulations which allow the estate trustee to hold on to assets if it's not the right time to sell.
Okay.
Like if you had a house today and you want to sell it, you may not want to do it because the market's pretty low.
Right.
Or if you have stocks and the company's tanked.
Yeah.
You don't want to be selling those assets at that time.
Okay.
So although a general rule might be 1 year, it fluctuates, depends on the asset base that you're dealing with.
Okay. So now if a person has properties or assets in different jurisdictions or different countries.
Right.
Say me being a South Asian, I have some assets in Canada, some in India.
Right.
Should I be preparing two wills or will one suffice for all assets?
So technically one will suffice.
Okay.
Except if you include your Indian assets in your Canadian will, when you go to probate, you have to pay Canadian probate taxes on the value of your Indian assets. And then you have to take that will and have it vetted in India and adopted by the Indian government or the Indian courts to say that this is the last will and testament of this person. So generally, our advice in that scenario is to tell people to do wills in the areas where they have assets, particularly when it relates to land or real estate.
So if someone has assets, say properties in Canada and US.
Yeah, so if you have properties in Canada and US, first of all, find out what the estate taxes are in both jurisdictions.
Okay.
Because US has more state taxes. If you have it in India even, then find out what jurisdiction it is in. And I would recommend you do a will in that jurisdiction in India, in US, and do one in Canada. But you have to be very careful when you do that, because one of the first statements on a will is that I revoke all previous wills. So you have to be careful that when you're doing a will in Canada and then subsequently do wills in other jurisdictions, you have to acknowledge that you are not revoking the Canadian will.
Okay.
That's for Canadian purposes. This will is for US purposes. This will is for India purposes. So you have to be careful in the drafting to make sure you do not inadvertently
revoke the other
will.
Okay, that's a good point. And then, so when someone prepares a will in Ontario, is there a registry system where you register that will, or it's just you do the will with the lawyer?
There used to be.
Okay.
That the Ministry of Attorney General used to have one that no longer exists. There are a few private services.
Okay.
And that's about it.
But no,
no formal institutional government registration.
Okay.
Yeah.
Okay, I see. And then Does a person need to come in person to sign a will, or can you do it electronically? Because of COVID, a lot of electronic signings were happening. So, is that a possibility, or does a person need to come in person to the office?
So there is the Law Society allows us to do it electronically.
Okay.
Okay.
Even the wills.
Yes.
Okay.
What happens is the physical document can the one of the witnesses has to be a lawyer,
Mm-hmm.
and then the lawyer's signature has to be original.
Okay.
Okay.
Yeah.
And even what you can do is you can have people on Zoom give the original document to the party, and the original sign,
Okay.
and the witness receives that document, original signs, and the lawyer gets that document eventually in original signs.
Okay.
I mean, that's my preference.
Yeah.
At COVID, I would go into people's driveways and just sit on the driveway and sign it, because
I see.
that's just my personal preference.
Yeah.
My personal preference is that if tomorrow something goes wrong,
Yeah.
I don't want to be judging myself to say, well, that looks like the guy I saw in the video.
Mm-hmm.
You know?
Makes sense.
So that's just a personal preference. But there are electronic signing is available under the rules of our profession.
Perfect. So, if there is a will which is improperly executed or witnessed, do the Ontario courts have the power to validate it?
Well, probate is a validation.
Okay.
Even if it's duly signed,
Yeah.
the probate process is a validation to tell the public at large that this gentleman presented court with a will, the court's accepted it, there's been no objections, and we've appointed this lady or man as the estate trustee. So that's what probate is.
Okay.
Whether you're saying in regards to whether it's being challenged, and then therefore, yes, it's not uncommon for wills to be challenged. And then again, there's case law and rules and regulations on what the grounds are for the challenging. Usually it's of the person wasn't of right mind, and often it is between siblings that challenges come.
Yeah.
Because maybe one sibling never did anything all their life, but had the expectation, well, I'm the child, therefore I must be getting something. There's no obligation on a parent to provide anything to anybody. If you're in your right mind and you want to give everything to charity, that's fine. If you want to give it to this animal that's lived with you forever and taking care of you and being a companion, it's possible. There's requirements, trust agreements, etc. You'd have to do estate trustees and stuff like that. And then you'd have to determine how the asset is determined upon the pet's death or whatever. So it's really in trust assignment. But so sometimes kids have this expectation that, oh, my parents have to give me everything. They don't. They can give it all to charity.
Okay.
Yeah. So because the court's assessment is, what was the intention of the person who passed away, and does this document that's being presented to me align with the intentions of that person? And that's why, as I said previously, a lawyer would often be called in on a challenge to say, what happened? What did this person tell you? Why did you draft it this way? Or why did you have a will and then it changed a year later and then it changed a year later? Because that kind of becomes a bit suspicious. Why is this will changing so often?
Yeah.
Well, maybe there were some significant life events happened, and therefore there was changes.
So on that point, if I had prepared my will five years back and now things have changed, I want to make certain changes to my will. Do I do an entirely new will, or is there any other document?
So a codicil is available. A codicil means it's a amendment to an existing will.
Okay.
The issue with that is that you have a will that was drafted 10, 15 years ago. There's been a life change event. Maybe you just changed the estate trustee, or maybe now you have different assets and you start adding more clauses.
Okay.
In my opinion, and what I recommend to clients, is you're better off starting afresh and accommodating both documents into one fresh document.
Okay. So just a new will
a new
rather
will.
than a codicil. Okay.
Codicils are obviously available.
Okay.
But let's
So for
say
small changes, a codicil
small
will-
changes, codicil may work.
How much does it cost?
Well, it's still time, right?
Yeah.
So you're still looking at an hour to two of work.
Okay, so around 500-600.
Yeah, 500-600, or
Okay.
depending on if that's a new call. If you're
Yeah.
more senior lawyer, then
I
it might
see.
be a bit more.
Okay.
But that's why I say if
Yeah.
you're going to do that, you may
Yeah.
as well
Do a
do
fresh.
it. And the problem with the codicils is if you do few too many codicils, what if you inadvertently cause a conflict?
Mm-hmm.
And that's why it's better to do a fresh document.
Okay, perfect. Now, what happens? I'll give you a few scenarios. What happens in Ontario if someone dies without a will? Now, that person has certain assets, but he was single, never married, no children.
All right. So if you die without a will, the estate trustee of last resort is the office of the public guardian trustee.
Okay.
Okay. And so what will happen is that because somebody has to arrange the funerals, other things have to be arranged, they, as a last resort, will come over to manage the assets. If
So
they
that's a
don't,
government body.
that's a government body. Yeah,
Okay.
I actually articled with them and worked as Crown Counsel
Okay.
with them many years ago. And so they're tasked with that role. They eventually, beneficiaries can come, like as you will know, there's a different tier of beneficiaries. Like there's you and if you're not married, there's you, then your parents, and then your siblings. So there's other levels of beneficiaries that can have entitlement to your assets, even if you're not married and don't have children. So they may come up and say, or somebody might come up and say, look, I have a power of attorney, or I have something, and maybe the public guardian trustee will say, fine, we've looked at you, we think you can manage this, you go ahead.
Okay.
So they are agents, they're the estate, the agency of last resort, but their goal is often to get somebody in place to get the work done.
Okay.
And if it's them, so be it.
I see. Same situation. In this case, a person dies without a will but has a spouse, no children.
All right. So if you die without a will, now you can apply to become the estate trustee without a will.
Okay.
And in doing that, you're telling the
So
court...
the spouse can apply.
The spouse can apply.
Okay.
And you have to understand that assets of an estate are subject to claims, particularly spousal claims. So even if you did a will and you left everything to all your children but left nothing to your spouse,
Mm-hmm.
that can be challenged because your spouse has rights.
Yeah.
So that's a bit of an aside. But the point being is that a spouse or any family member, if you don't do a will, any family member could step up and say, I will do that. Like I've done. We're getting into an age now where a lot of my clients are elderly siblings.
Yeah.
And, the sibling dies, but they have no spouse, or they were divorced, they have no children. And now often you're getting siblings applying to say, I will be the estate trustee for my sister or my brother, and they may all be in their 70s or 80s,
Okay.
right?
Yeah.
So any person can apply. And sometimes even it's people who have vested interest in the estate, like maybe somebody who's owed a lot of money, or there's debts that they want to collect on. They may if they can justify to the courts why they would be a good estate trustee, they could potentially get appointed as well.
I kind of know the answer to this one, but I'll still have you answer this. Same situation, a husband, wife, both die, they only have children, no will. What happens?
Then the children would apply.
Okay.
Now, if the children are minors,
Yeah.
then you'd probably have to have a same level sibling or somebody to apply on behalf of the children.
Okay.
Yeah. Now,
No.
on that point, that's what I would like to emphasize, that you don't want to leave your children in a complicated situation solely because you just didn't feel comfortable or confident doing a will.
Mm-hmm.
One of the reasons, particularly if you have minor kids, is how are you going to assign somebody to take after those kids? Because
Yeah.
if you don't do it in a will, now somebody has to apply to the courts for guardianship of
Yeah.
person and guardianship of assets for the minor children.
So that's my next question
okay, good.
is, so should spouses have mirror wills? I'll give you an example. Me and my wife have 2 children.
Right.
I want the children to be taken care of by my family.
Right.
My wife wants the children to be taken care of by her family. Both children are minor,
Yeah.
right? How do people navigate such situation?
All right. So first of all, you can't have a mirror will because
Okay.
you have two different intentions.
Yeah,
Right.
yeah,
And the best way to navigate that, I would suggest, is you and your wife have a discussion, and look at who you're looking to appoint. Do they have like if they have 3 or 4 children,
Mhm.
can you burden them with 2 more children?
okay,
Will they have the nature that you're expecting your children should learn from?
okay,
So it's not so much my family, his family.
yeah,
It's more of, for the benefit of our children, which of our relative
mm-hmm.
would feel comfortable doing that and have the value system and the nurturing behavior that we would want them to learn from.
Okay.
Right, like
so
if-
if both spouses decide that, okay, we want them to take care of our children, then it kind of becomes a mirror.
But then talk to them.
Yeah, for sure.
Then talk to the guardian and say, hey, we're gonna give you this responsibility. You up for it?
Yeah.
Because the worst thing you want to do is appoint somebody and the guy goes,
I don't take
I
that.
can't do this.
Okay.
Right.
So what happens in that situation?
Well, then you got a problem. Now somebody else has to go and get a guardianship application.
I see.
Right. So
Okay.
so it's better. That's why I think the key to wills is you as a person need to be able to have that discussion with yourself,
Yes.
with your spouse,
Yeah.
with your beneficiaries, and then anybody else that you may have to rely on to do what you want them to do for you.
Absolutely. Now, can you give me some situations or examples of when wills are contested?
Wills are generally contested when the people who are left don't get along
Mm-hmm.
or have a misunderstanding of what mom or dad might have done. And I'll give you an example. Like as a senior, right? If you can't live on your own, you're going to live, and particularly with our extended family, South Asian culture, you're going to live with one son, or you might live with a daughter, or culturally, you're supposed to live with your sons, but you might live with a daughter. And so it might be that you're close with one, and as I gave you that previous example, if you're with one and you want to appease your child, oh no, I'm leaving everything to you, don't worry, fikr mat karo, aapko hi dunga sab kuch.
Yeah.
Then you go to the next child's house, and then you don't want a conflict, so you're like, no, I'm leaving everything to you.
Yeah.
So now you've left a misconception
Right.
amongst your children
Created a conflict.
because you didn't want the conflict.
Mm-hmm.
You're better off saying, this is what I'm going to do. Because if you get the conflict, it's in front of you,
Yeah.
right?
Yeah.
And then you can make an assessment, well, if this is what's going to happen, is this even what I want to do?
True.
Maybe I wanted to leave it to a religious organization,
Mm.
But we love to avoid conflict.
Yeah.
So that's where anytime you have parties with a misconception of who was to get, or expectations
Yeah.
that are not necessarily true,
Yeah.
you may well get challenges.
And if someone prepares a will or changes their will just before they die, is it a red flag?
As I said earlier, if life events change, you may want to change your will. It depends on the situation of the person. If the person is in ICU and somehow the will gets changed, one might say this is a bit questionable because you have to have capacity.
Mm-hmm.
So whether you have physical capacity or mental capacity, both of those, if you can't sign the will and all of a sudden there's a signed will,
Yeah.
you're going to challenge that.
Yeah.
So any change that is close to death, people have change of heart. I had one guy who had, he drafted his will. He didn't want a certain child to be present. He didn't want the spouse of that child to be present. He
Present
didn't want at his funeral.
Funeral. Okay.
Didn't want them to, and as he's terminally ill in hospital, he had not given them any blessings at their weddings.
Okay.
He had not attended their weddings. And this was like 30, 40 years ago.
Yeah.
he in his mind reconciled
Okay.
that no, that was wrong on me. They came to his hospital bed. He gave them the blessings. He gave them the saris and shirt and everything that he should have done when they got married. He reconciled with himself. He reconciled with them. Then I get a phone call.
Yeah.
He goes, "Don't give my will to anybody."
Mm.
And I'm like, because he had all that language in there.
Right.
That I don't want to give anything to this person because
yeah.
this was like this. And so now he felt bad. So I was in a dilemma. Well, eventually the assets were okay. We didn't have to probate, so nobody had to see it. But it depends why the will has been changed.
We are also proud to be sponsored by Kapoor Vastralaya, with locations in Mississauga, Ontario, Surrey, British Columbia, and Fremont, California. For the finest selection of ethnic Indian clothing, visit your nearest store and explore their beautiful collection. And just for our subscribers, you can get a one-time discount coupon by visiting thekapoorpodcast.com and filling out the form. Have people done a will on a deathbed or in a hospital? Have you seen such situations?
Yeah, it may well happen. I mean, I remember in law school, I don't know if you remember, one of the famous cases was a farmer was out in a field and he got injured. And with his own blood, he wrote a statement on the bumper of his tractor. And that was a valid will.
Nice.
Right? Because he said, I give everything to whoever.
Yeah.
And that was considered a valid will.
Okay. So now, should adult children have a part in the will, even if their names are not there?
So I'm going to take you back to basics. The will is the testator, the person who dies. It's their intention.
Mm-hmm.
The goal is that document is purely their intention, and there is no undue influence. So with our families, our seniors may not be driving. They need to be brought to the lawyer's office. Obviously, the children will bring them physically to the office.
Yeah.
But when you're executing a will, there can be nobody present but the testator.
Right.
Because tomorrow, if you're asked, you have to be able to say, yeah, it was me and that person, and I asked all these questions, and it was clear to me it was that they were not under duress, they were not under influence.
Yeah.
This was their will. This was their wishes. So in that regard, there will always be a level of assistance, because if you're living with your family, somebody has to bring you there.
Right.
But they cannot participate, like sit and now my dad says, like, you cannot take instructions from a phone call, calling on behalf of my father, and my father says that everything should be left to me, and can you go and draft a will?
So even if the children are paying for the preparation of will or whatever, it should always be between the party who's signing the will and the lawyer.
Well, you bill your client.
Okay.
And your client is the person doing the will.
Okay.
Yeah. I mean, you may not know where the money comes from paying the will, but you bill your client.
Okay.
Yeah.
Perfect.
You have to be, as a lawyer, we always have to be client focused.
Yes.
Yeah.
Absolutely. I think you've covered this, but I'll ask you again. Can someone leave their entire estate to a pet or maybe a celebrity?
I mean, a celebrity is a human. If it's a human being, that's just like leaving it to anybody else.
Okay.
If you were a fan of Rajnikant or something,
or
Amitabh Bachchan, and you want to leave them money, I'm sure they won't say no. But a pet, the question of a pet is that the pet can't manage the money.
Yeah.
So now you have to add an added layer of administration. So you're going to have to leave it to your estate trustee.
Okay.
And then give the estate trustee rules and regulations on how the funds are to be used for that pet.
Yeah.
And in essence, it becomes a life interest, because until the pet is alive, those funds would be used. And I have drafted those wills now that I think about it.
Yeah. So it's legal.
Yeah, I've had clients give me those instructions.
Okay.
And just like a child, you then put a person in place to take care of the pet. And then you have to address, well, if the pet dies, where does the estate then go? And so you still may have to then have another layer of distribution, which says, in the event the pet dies and there's still money left over, then it's to go to X, Y, and Z.
Okay.
So it's feasible.
Yeah.
It's not a simple will anymore.
Okay.
There's other things that have to be taken into account.
Perfect. And now a lot of people are investing into crypto and cryptocurrencies, bitcoins, what have you. Can you incorporate that into your will?
My thought is you probably can. We're allowed in Canada, or at least in Ontario, we're allowed to do a primary and a secondary will.
Okay.
So a primary will then deals with assets that you would have to probate, for instance, real estate. A secondary will can deal with shareholding in a private Canadian corporation. So if you have your own business and you want your family to get the shares in the business, that is non-probatable. It doesn't need to be probated.
So you do two wills, a
you can do
primary
two
will
wills.
and a secondary will.
And
Okay.
again, when they're done to say I'm not revoking each other. So
Okay.
there's particular clauses.
So
that
just to be clear one more time. So primary will, you will have your real estate in there,
In essence,
and
yeah.
certain assets, and then secondary will have your business, maybe
Or
your
other assets.
cryptocurrencies, stuff
Yeah,
like that.
Yeah.
Okay.
And so then when you get into cryptocurrency, or I know people have, web pages and stuff like that, what you always have to do is initially make inquiries from those organizations that in the event the authorized person with all the codes and the passwords
So that's
passes,
about say if you have social media accounts,
social media,
and
let's say, or
a lot
even
of
crypto,
following or
because
whatever.
crypto has a lot of, I
Yeah.
don't own any, but it has a lot of passwords from
Yes.
what I understand.
Okay.
But my point being is that when your asset is now within the control of another organization, before you can determine how that asset can be distributed to the next level,
Mm-hmm.
you need to make the necessary inquiries to say what rules or regulations those institutions are requiring of
Check
you.
with those companies. Okay.
And so then when you've known that, then
Yeah.
the person who's drafting the will can say, okay, so for this asset, this is the process to get the transfer of the passwords, this is the process to get access, et cetera, et cetera.
Okay.
So, to get the website assigned over, to get the whatever is necessary, right? Because
Yeah.
there can be value in those assets.
Okay.
Sometimes it's emotional value, but there can be financial value too.
Okay. So we covered electronic wills a little bit. So are both handwritten wills and electronic wills valid in Ontario?
When you say electronic, are you saying like they're typed, or are you saying the execution?
Either or. So maybe just type, you said it's not valid.
Well,
it's
let me
not a
step back.
holographic.
It's not a holographic
Yeah.
will.
Yeah.
If you want a holographic will, that's defined.
Okay.
All in writing,
Yeah.
signed by you,
Yeah.
dated, no witnesses.
Yeah. Say electronically executed.
Electronically executed, we have rules under our governance that allow us to do that,
Okay.
as long as you maintain that
Yeah.
and the obligations are properly performed. That is a validly executed will.
Okay. If someone uses AI or an app to prepare a will, right, and it's challenged later, whose responsibility could it fall on?
He'll probably fall on the estate trustee.
Yeah.
So if you do AI, because conceptually, AI goes out there, picks up a whole bunch of data, and tries to align it to you.
Yeah.
That's what my understanding of AI is. And at a basic level, that doesn't align with a will. The reason it doesn't align with a will is because now that's what AI is telling you the world's intention is.
Mm-hmm.
That's not what a will is for. A will is for your intention.
Yeah.
The best way to express your intention is speak to a legal advisor and get a will done properly and make sure it aligns with your intention.
Mm-hmm.
If you were doing... I just don't think in this realm the AI drafting of a will would be productive.
Okay.
Yeah, it might be productive in that maybe if you and again, it's the parameters you set, right? So if you say, I want you to look at the forms of drafted wills in Ontario and give me a basic will,
Right.
that might work.
Yeah.
But again, the document's intention is your intention.
Right. Yeah. So it might not be
It
able
may
to
not
give
be
the-
appropriate.
Okay. Okay. Perfect. And so if someone remarries, right, and now leaves the entire estate, all the assets to the new spouse, does not leave anything to the previous spouse or children. Is that challengeable?
Anything's challengeable, but I think the point that you've raised is you have a set of obligations to a previous spouse and previous children. You now, presumably you've divorced properly and all the paperwork has been done to address those obligations, and now you remarry. If you do a will that does not acknowledge and ensure that the obligations under the previous relationships have been, like, let's say they're all settled, like everything's been distributed, the kids are all major age, you don't have any more obligations, then you won't really have a conflict.
Yeah.
But if you fail to ensure the prior obligations are not fulfilled at your death, if they're still outstanding, then it can be challenged.
Okay.
So it might say something to the effect of, I leave these assets to address my obligation to my children under separation agreement or under whatever the court orders that were previously issued, and then the rest of my assets I give to so-and-so.
Okay.
So any time that if you have a legal obligation that you're supposed to meet,
Yeah.
and you try to ignore it, that's going to cause you conflict in a subsequent will.
Okay, perfect. Now, wills are, I think these are private documents. Do you think that any parts of a will should be available to the public?
Oh, no, like you said, they're private documents. So you've had cases where people have the wills in court but have them sealed.
Okay.
Because there's a conflict because there's significant assets that are being dealt with, and that's not part of the public domain. So in that regard, it is a private document. Therefore, it's confidential to the person.
Yeah.
Generally, you can't then say, well, I'm not going to give it to my estate trustee, because how will your estate trustee know what to do?
Right.
So there is some logical disclosure that must happen for it to be fulfilled.
Yeah.
But in general, it's a private document.
Okay, perfect. I think we've covered most of it. This has been amazing. Do you have any last piece of advice that you would like to give to our listeners?
I think you need to address your concerns. Like, death is a funny thing. People think if I do a will, I'm going to die. Well, irrespective of whether you do a will or not, you are going to die.
Sure.
One day.
Yeah.
Or when it will come, nobody knows, but it will come.
Yeah.
So my advice to people would be, take the responsibility of acting proactively, deal with the right people to do the right work to achieve the objective you have. So be clear in your mind, what's your objective? Where are your assets to go?
Yeah.
Be clear in what you tell your advisor. And then once you're looking at your asset base, get the right information from the appropriate professionals, whether it be accountants or financial planners, so that your lawyer will know these are, or like the digital stuff. So you know that, yes, I've put all the codes in the right place and blah, blah, blah. So that's what I would say, because as much as people think we provide a service, we want to make reasonable living. We're not, but I'm not here to say, if you can do a holographic will and you're dead set on it and you have to do it, so be it. But there might be consequences. And those are consequences that you could have avoided by having a discussion with a lawyer. Because sometimes they'll say, put this asset to this person's name, and they don't consider the tax consequences. And what they thought was a $100,000 asset is like down to $20,000.
Right.
So what their wish was to give something significant to a beneficiary, and they haven't achieved it. So that's why I think in this realm especially, the assistance of professionals is very important.
Perfect. This has been amazing, Mr. Sharda. Thank you so much.
Thank you for the opportunity. Appreciate it.
This episode of the Kapoor podcast was proudly sponsored by Kapoor Law Firm and Kapoor Australia. If you are enjoying the show and want a one-time discount code, head over to our website, thekapoorpodcast.com, and fill out the form to receive your subscriber-only discount code. Whether you're looking for legal expertise or premium Indian ethnic wear, our sponsors have you covered. One more request to all of you, please do subscribe to the show and leave a comment to let us know what you think and how we can improve. We'd love to hear from you. Thanks for watching and see you in the next episode.